SJC-09814 Commonwealth versus Lopes.
Good morning, Ms. Forge.
Good morning, Your Honor. May it please the Court. The first issue I'd like to address is the one involving that the trial court erred in denying the defendant's motion to suppress. In this case, the police lacked reasonable suspicion to stop the van. They lacked probable cause to search the van, and they questioned the defendants after they indicated they wished to remain silent. In this case, Brockton Police was given a radio broadcast which said only that there was a dark brown van, a dark brown tinted van with a Cape Verdean flag in the back of it. What they said, stop and hold. The Boston Police did not alert the Brockton Police to the other information that they had, specifically that all they knew about this van is that it was on the scene 15 minutes or so before a murder possibly took place.
Well, I'm sorry, is that all they knew? I mean, when I look at the Commonwealth's brief, it indicates that the eyewitness said that there are two people who were in the car for no apparent reason for quite a period of time. Was that not known at the time?
That was not known. That was not known by Brockton. Boston had a host of information that they did not convey to Brockton. And I was just telling the information that would have been relevant to how Brockton handled the situation.
And is it your position then that the knowledge that is relevant to determine reasonable articulable suspicion is the knowledge only of the Brockton PD as opposed to Boston PD?
That is correct. It's the knowledge of the officer at the time he effected the stop. Otherwise,
What is the authority for that proposition?
well, there are no cases that say that I could find anywhere that said knowledge not known to the officer is relevant. And the reason for this,
on probable cause, I believe we've always said that for probable cause, the knowledge of one investigating officer is the knowledge of all. I don't know any
if it is
cases.
conveyed to the others.
Excuse me?
If it is conveyed to the others.
I don't believe so, not for probable cause.
Well, if I may, otherwise the police could randomly walk the streets in high crime areas, pick up people, search them, and then justify it by saying, oh, well, some officer back at the station knew that there was a warrant for this man.
I believe the rule is that those working on the case. I believe that is the rule. The knowledge of one is the knowledge of all.
I don't believe there is any case that says that if it's not known, because otherwise the only thing known by this officer was that a dark brown van with tinted windows. And if we allow him to stop a bright burgundy van with a flag in a different location in a Cape Verdean community than what he was told, it allows him to do, it sets a very, very dangerous precedent.
But
it
it
allows
doesn't
him
make
to
any
go
sense.
back and justify.
It doesn't make any sense, because otherwise police officers working on a case would all have to somehow be plugged into, it's like, I mean, it's almost comical. It's like the Borg, or whatever that thing is in those science fiction movies where they all somehow know exactly what all the others know. We do it by a legal principle of attribution.
Let me give you an example. Suppose that they had just been notified that a van was involved in a murder, and they started stopping every van. You couldn't justify the stop of every van based upon the fact that...
But it isn't every van. It was a large-sized van that had like 4 aisles in it. It was reddish or brownish, and it had a Cape Verdean flag on the back.
But Brockton didn't know that.
Tinted windows.
Brockton didn't know that, and Brockton stopped a red burgundy van. The only thing that matched the description the Brockton officers had with the van that they stopped was that it was a van and it had tinted windows. The color was wrong. The location of the flag was wrong. And if you allow Brockton...
Excuse me, what information did the Brockton police have?
The only information they had was that and I'll read it to you, Your Honor, Brockton cruisers, be on the lookout for a dark brown tinted van, Cape Verdean flag in the back of it. It's the only information we have. Homicide in Boston today by handgun, dark brown tinted van.
Right. So to pick up with Justice Cowan, so you've got people working together, and they know that they are looking for a van with a Cape Verdean flag with tinted windows.
They're looking for a dark brown.
Well, that's
Verdean
one
flag.
piece of it, okay? It's one piece of it. So what you're really saying, it seems to me, that if the Boston police had stopped a red van that would not be. I mean, it's on a different ground. Police are using, they get a description, they know that descriptions vary somewhat.
But color?
Yes. We often have cases where somebody says, I think it was blue and it turns out to be green.
Well, I do understand that, but this is the only thing that they
I
had.
understand, but they are acting on information that they validly received, right? And it's not as if they stopped a silver Mercedes sports coupe, right?
Correct. But I would point out that the Boston police stopped 2 other vans.
Yeah.
So you are authorizing this general... You're authorizing a general search of all vans with tinted windows?
No, with tinted windows with a Cape Verdean flag.
But again, you're in a Cape Verdean community. 70 to 80% is what the officer testified to.
I understand that, but that doesn't have to do with the knowledge of the police officer. That's you saying that a police officer, whether Boston or Brockton, is searching too broadly beyond the description.
That's exactly what well, that's one of the things I'm saying, Judge, because the only thing that he had knowledge of, first of all, they didn't convey to Brockton that this was only a van of interest because they had no evidence at that time to justify an arrest of the occupants. What they did convey, they implied that this was a van that was involved in the homicide, which is one issue. But the second issue, Judge, is they gave an incorrect description to Brockton, and then even with the incorrect description...
Is it incorrect, or did they give a description that they had received from a witness?
That's correct, Judge. It did not match the van that the witness eventually identified. That's all I mean by that. So they gave an incorrect in the sense that the witness said there was a Cape Verdean flag in the front, and indeed there was a tiny, if you can, and I left the pictures in the appendix, a tiny little thing that hangs from the rear view mirror. That was in the front. The description was incorrect, and it said that it was in the back of the van.
It seems to me that you're interjecting a degree of almost perfection that's not required under the law.
Hardly, Your Honor.
What the police officers did here was reasonable. It was within the realm of the description. It was consistent with the description that was given to them. They stopped a van that was similar to the description that was given to them over the radio.
The only similarity was that it was a van and it had tinted windows.
And it had a Cape Verdean flag on it.
In
And
the
it was
wrong
a large
spot.
van.
It was a large
It
van.
And
wa-
all those things narrows the universe quite a bit. And while we've been discussing this, I've located 2 appeals court cases, at least, that state that probable cause is evaluated on the basis of the knowledge of all police officers. Now, I think if you're trying to narrow that down to just what this officer knew, I mean, that's really very, it's not a working, that doesn't work because everybody's working on it together.
Respectfully, Justice, the large van was not conveyed to Brockton. They were just told
I
a van.
understand, but I said that we have at least 2 cases from the appeals court that say the probable cause is evaluated on the basis of the knowledge of all police officers. And I've asked you if you have any contrary authority, and you say you don't.
The cases that I saw, Judge, and involved where one police officer received knowledge from another police officer, and even though that specific police officer did not have personal knowledge, it was conveyed to him from another police officer. That I'm not disagreeing with at all. I believe that had the Boston officers given all of the information to Brockton, namely a description of the occupants, the fact that there were a large number of windows, the fact that it was a large Dodge van, then indeed Brockton would have had the right to stop this van, even though the color didn't match and the flag was not in the correct spot. However, we have to judge, did this police officer act reasonably? Did he have a reasonable suspicion, or was he just acting on a hunch? And the information that was provided to him was nothing more than a hunch, dumb luck, and a good guess.
It wasn't good police work.
I think that under this description, a tremendous number of vans could have been stopped in Brockton. The mere fact that this van was stopped at a light in front of this officer, because again, he's looking for a brown van, he stops a bright burgundy van. We're in a Cape Verdean community.
Burgundy and brown aren't that far apart when a witness is making an identification under very trying circumstances.
Well, this witness also was taken to the scene of another van the Boston police stopped that was burgundy and said, no, it's the wrong color.
But that's different. Ms. Horwich, it seems to me that we're, I don't want to beat a dead horse, but we are mixing up two concepts. I tend to think that where Justice Spina is that you look at what the Brockton police officer had and said, is stopping this van reasonable, and you say no.
Well, then what would stop a Boston police officer walking the streets, arresting someone, knowing that maybe his friends in the warrant unit might know whether they had an arrest warrant out for them.
Because here you have a Brockton police officer who's given some information, and then you have to look at what he did and to say, is that sufficient information? From my point of view, that's how I would look at it. And I tend to agree with Justice Spina that it may have been dumb luck, or it may have been good police work, or it may have been that he knows that neighborhood and knows that there are not a lot of vans. I don't know, but the question is, just based on what he had, is this beyond the realm of possibility? And my sense is it's not.
But then, Your Honor, allows the police just to stop anybody for any reason as long as they can back justify it. And that's the dangerous precedent.
No, it's not back justifying it. I'm looking at what he knew at the time. What he knew at the time. I don't have to get to if he knew nothing. I don't have to get to your hypothetical. I'm nowhere near your hypothetical. I'm looking at what this police officer actually knew and whether his action was reasonable in light of what he knew.
Well, even if we look at what he knew, the description was so broad and so vague that it could encompass a tremendous number of vans. In fact, 2 other vans had been stopped already in Boston. What we also have...
What's wrong with that? What's wrong with the fact that they could have stopped 10 vans based on that description? Was it unreasonable to stop 10 vans?
I would suggest so.
So under your theory, you can only stop the van that was involved in the crime.
Not so, Your Honor, respectfully. If the description had been what the Boston police had, now the Boston police had more information, which they didn't convey to Brockton. If they had a I mean, we don't even have a license plate. We don't know that
They
the
didn't
van...
have a license plate?
We don't know that it was a large van. Brockton doesn't know that it was a large van. Brockton doesn't know that there are lots of windows. They stop a van that is distinctive not only for its color, but for the large number of windows, for the scrapes down the side. It's a distinctive van, yet none of this was known to them, and this is something that a witness would be likely to say. And that was not conveyed to Brockton. For that reason, they did not have the right to stop the van. The time is also an issue. I mean, here is a van. It's about an hour and a half later. It's 25 miles away. It doesn't support the fact that this was just used in a robbery. It could have been just a Cape Verdean individual driving in a Cape Verdean community.
Why is that? I mean, the problem would be if it was 5 minutes away, then there would be a problem because you can't get from Roxbury to Brockton in 5 minutes. But you can certainly get there an hour and a half or 2 hours.
Exactly, but it doesn't support it because if the question that they had was, were you just in Boston? Well, if they were just in Boston, it would have been half an hour ago, not an hour and a half ago.
Well, they didn't have to drive directly.
No, but they said that they were just in Boston. The thing is, if this were a perimeter search, then that would be supportive evidence. But a Cape Verdean van in a Cape Verdean community does nothing to bolster the probable cause or the reasonable suspicion. It would be like if there was a bank robbery in Sharon or Roxbury involving an African American, and you say, well, let's look in Roxbury. A half an hour or two later, it doesn't do anything to support the fact that occurred. And this is all that they have here. I would suggest just going back to an issue with the Hensley case, which is cited in my brief, as well as the other cases. The courts are quite clear in imputing knowledge of one officer that is conveyed to another officer. I would just suggest that where it has not been conveyed, we risk an extraordinarily dangerous precedent.
Well, I'm having trouble understanding the concept that you just described. Imputing knowledge of one officer does not require a communication of all the knowledge, does it?
I believe it does, Judge.
Well, then why would there be an imputation?
Well, it is not such as an imputation. It is saying that they don't have to have personal knowledge of it if it is communicated to them. And if you look at the cases, that's what the cases say.
But the officer who is communicating the information doesn't necessarily have to have knowledge of it.
The officer who's communicating
So-
has
so-
to have a
but-
reasonable basis for that knowledge, and as long as he has a reasonable basis, the reasonable basis is imputed to all the other officers that obtain that knowledge.
So if there's communication down the line 2 or 3 levels, it's no good.
On the contrary, it is good. It's the communication that makes the information the justification of the stop, because we have to look at the officer's intent, his objective, I mean, not his intent, but objectively what this officer has, why he's making the stop. If he doesn't have that information,
So
he's making
what
a
other
bad
information
stop.
do they have to have here?
I would
Do they
suggest,
have to have information that the van was parked in the lot right next door?
well, no. If the officer would have been acting on good faith, if he'd been, he thought that this van was involved in a murder. He wasn't told it was just a van of interest. I'm not saying the officer was not acting in good faith, stopping a vehicle if he'd had more information. But in this case, all he had was, it's a dark brown van with a dark brown van with tinted windows and a Cape Verdean flag in the back.
And they weren't told that it was involved, they think it was involved in a homicide?
Yes,
They were told that?
yes,
Okay.
yes. That's what I read to the court. And so that's, even though the Boston police had no evidence that it was involved in the homicide, only that it was there at the time or around the time of the homicide, as was the witness. That's all the information they had. They implied to Brockton that it was involved in the homicide. So that's what the Brockton officer thought. But again, if you allow this, if you justify what the Brockton officer did, it would allow any sort of van to be searched, any sort of vehicle, because the color, I mean, it's critical that we have something that identifies this van from the multitude of other vans. And if color is not good enough, there's not much, just
Cape
tinted
Verdean
windows
flag attached to the van?
attached to the front of the van. And that's, it's just inconceivable to think these people would decide to hide their van by taking the front flag in the front and moving the flag to the back. It's just not a good way to disguise a vehicle.
Yeah, but they're not being charged with not having disguised it well. They're charged with committing a murder.
Exactly. So to stop something, one needs to have an idea of what one is stopping. It's not sufficient just to stop a van with tinted windows. And that's the only thing. There was a Cape Verdean flag.
It isn't the only thing. There was a Cape Verdean flag. It was in a certain color range.
In a Cape Verdean community. Again, if they'd stopped
So
it...
do all Cape Verdeans in Brockton put flags on their... they all drive vans and they all put flags on their vans?
I would-
Big vans, large vans.
No, not large vans, Judge, because that wasn't known to the Brockton police. And
Well,
that-
it was known to the Boston police.
It was known to the Boston police, and the problem is Boston never told Brockton, so Brockton's acting on a hunch.
So do all vans, do all Cape Verdeans in Brockton drive vans with flags on them?
I don't have any idea. I would suspect not, but I would suspect that there would be lots of shows of homeland love and loyalty in that community. Just as we drive around, we see lots of cars with the support our troops on them. You wouldn't expect to see that in England, or I should say France, but you would expect to see that here, so it loses its distinctive value. Now, Lopes, they stopped the van at gunpoint. They questioned Mr. Lopes at gunpoint, and he responded.
Is there anything wrong with having drawn a gun?
Well, if I would suggest, the police safety is obviously a big concern. Had Boston conveyed properly to Brockton that this was just a van in the area of it, the amount of concern would probably be less. If this van had shown any indication of improper activity, I would say...
These are two different issues. Let's assume for a moment the police had a reasonable suspicion, a basis on which to make this threshold inquiry. This was a van that was reported to be related to a homicide that had just occurred. Don't you think that the officers, with that information, acted reasonably in having their weapons ready?
Weapons ready is different than weapons drawn.
Weapons drawn, okay, weapons drawn.
One of the officers had it holstered. One of them had it drawn.
But the van, when they saw the van, it had tinted windows. They had no idea how many people were in the van or what they were doing inside the van.
and it was a van with a different color than the one that they were looking for.
Separate issue. Let's get past reasonable suspicion. They've got reasonable suspicion, let's assume, now, so they have a basis on which to stop the van. At that point, the van is being stopped because it is connected to a homicide in Boston which has just occurred. Isn't that enough information for the police officers to take steps like drawing their guns?
But then they're questioning them at gunpoint, and they were.
What does questioning them at gunpoint mean? I mean, when they got them out of the van and put them on the sidewalk, they had guns drawn on them. Was that while they were asking them questions? Is that what you're saying?
No, Your Honor.
I didn't read that.
I'm not saying that at all.
Okay.
What I'm saying is, one of the officers had a gun pointed at the van. The other officer said, "Were you just in Boston?" These people, it's certainly didn't think that they were free to leave at this stage. They are held at gunpoint. They weren't acting furtively. They weren't acting secretly. They weren't trying to make any sort of gesture that would alarm the police.
Well, the very fact that this van is being stopped because of its connection to a homicide that has just occurred, isn't that enough? You don't have to do none of these other things matter. If this was just a stop for some completely unrelated, a reason totally unrelated to a violent crime, I take your argument that they've got to do something to prompt suspicion. But here...
Well, here's the thing, Judge. Now you're saying that all they knew that this van was in the area of a vicinity. All Boston knew was that this van was in the area, a potential witness. Nothing more, nothing less. In fact, the Boston police told the Brockton police to let these people go. If you're going to impute knowledge to Brockton, you have to impute the stuff that hurts them, and there's nothing that what's known to Boston, not was that this van was involved in a homicide, but it had been on the street where a homicide had occurred at some time 15 minutes or so before the homicide had occurred. So, no, I don't think the police had the grounds at that stage. They could have followed the van, they could have seen what happened, they could have just watched, but they did not have the information at that stage, because if you're imputing knowledge, there's no knowledge that this van was involved. There are no witnesses that saw this van take off. There's no witnesses that heard peeling tires, anything that would indicate that this van was involved. And in fact, even after taking the money, Boston police realized this and let Mr. Lopes leave.
Thank you, Ms. Horwich.
Thank you.
Good morning, Ms. Lee.
Good morning, Chief Justice. May I please the Court? My name is Macy Lee, and I represent the Commonwealth in this matter. I ask that the Court affirm the defendant's conviction for first-degree murder and the other two.
Let's assume for a moment the van, this van was stopped. Same fact scenario. The officers take the two individuals out of the car. They search under the front seat. There are no guns. There's no proceeds. There's just some drugs under the front seat.
I think
they're
that
charged with a drug offense. You telling me that the stop of this van was based on reasonable suspicion to support that kind of search?
Well, I think in the hypothetical that you gave me, it would depend, again, on what the nature of the broadcast, the information.
Exactly like this.
Exactly like this.
Exact same information.
I would submit to this Court that that would be a constitutional search, because, again, given the fact patterns that you gave me, including the similar broadcasts that exist in the present case, that this was a van wanted in connection with a homicide today in Boston.
A van. Okay, so we have a van.
Well, no, actually, I should
You
back
say
up.
van or man?
A van.
Okay.
Actually, the exact broadcast that Brockton received was, and I can read it to you, Brockton Cruisers. Be on the outlook for dark brown tinted van, Cape Verdean flag in the back of it. It's the only information that we have. Homicide in Boston today by handgun, dark brown tinted van, Cape Verdean flag in the back. Stop and hold.
This
Use
van was
caution.
not dark brown. It didn't have a Cape Verdean flag in the back. All right, so this is not a very...
That's correct.
This is... And it's 25, 30 miles away and a couple of hours afterwards.
Actually, it was an hour and a half afterwards.
All right, 2 hours.
It was an hour and a half afterwards. The appellate courts in this state have consistently held that an exact fit of the description of a broadcast is not required. And we have cases as Ancrum and Manipur, I believe also in Cullen and Riggins, where there is a detail or two that's off from the description that was given in broadcast, and nonetheless the courts, including this court, has held that the stop was nonetheless constitutional and that reasonable
Ms.
suspicion
Lee,
existed.
may I ask you this
Yes.
question? You just led, this was a dispatch to Brockton Police.
That's correct.
Was there some reason why the police in Boston selected Brockton?
Yes, I think it's important for the court to sort of understand the entire timeline, which you probably already do. The victim's cousin, who's Antonio Fidalgo, actually observed the van in the area of Clarence Street in Roxbury. The murder occurs. He notices the van that was parked behind his minivan was no longer there. Police arrive. Officer Bliss arrives within minutes. Within 15 minutes after he talks to Antonio Fidalgo, he then made a series of 6 to 7 broadcasts. The first one included the van, that the driver...
And the broadcast goes to whom?
I'm sorry?
And the broadcast goes to whom?
To all the Boston police, just in Boston. It was
Okay.
just for Boston police officers. So there's a series of broadcasts made within a half-hour period that consisted of 6 to 7 broadcasts, including the description of the van, the description of the driver. So there's more forthcoming information as Bliss is talking to Antonio Fidalgo. Officer Ridge, who is a member of the Fugitive Task Force with the U.S. Marshals, he works very closely with Detective Cummings in Brockton. He's also made numerous arrests of people of Cape Verdean descent from the Brockton area. He then, at 10:30 precisely, contacts through telephone, not through broadcast, to Detective Cummings, who then receives the call. And the information that he did receive was that there was a brown van, tinted windows, dark-skinned Cape Verdean male driver wanted for questioning or in connection with a possible shooting. That was the information that Detective Ridge relayed to Detective Cummings. Then at 10:30, Detective Cummings, with this information, contacts a dispatcher at the Brockton Police Department and gives him the information that the Boston police officers were looking for a van involved in a homicide. It was a brown van, tinted windows with Cape Verdean flag in the rear. He was also told that it was a shooting-type homicide, and that resulted in the ultimate broadcast that was received by Robert Smith, who happens to be doing detail work on Warren Avenue in Brockton. His shift
You still
starts-
haven't answered my question as to why Brockton.
Why? Again, because Officer Ridge's knowledge and his subsequent...
Of what?
Of making... Well, based on Antonio Fidalgo's description of the van, that it had a Cape
No,
Verdean
I'm
flag.
not worried about the van. I'm saying why Brockton as opposed to other,
Other communities.
yeah.
Fall River, New Bedford.
No, absolutely. But I think because based on just Officer Ridge's experience with Brockton and having worked with Detective Cummings closely in the past, he decided, and it didn't come across during the suppression hearing, to contact Detective Cummings just to give him the information.
Well, no. Didn't he know that, or was based on his experience? Did he believe that there was a high concentration
Yes.
of Cape Verdeans in Brockton?
Yes,
in more than in other communities.
That's very correct. Yes, that's absolutely correct.
And that's in the record.
That is in the record. That,
More than in New Bedford?
I believe that was his testimony in the suppression hearing. That it was based on
What,
his
that there are
experience.
more Cape Verdeans living in Brockton?
Based on Officer Ridge's testimony, apparently yes. That was his testimony, and that's based on his experience working on a fugitive task force with Detective Cummings. And I believe that testimony also came out at the suppression hearing through Detective Cummings.
Now, with regard to the stop, it seems as if it's not really the collective knowledge that's at issue, since I don't think Ms. Horwich is arguing that the Brockton police should not be said to have understood that this car was wanted with regard to a homicide. It appears to be the singularity of the description. I mean, do you agree that if the description was brown van with Obama Biden sticker on the back, that would not be sufficient to justify a stop?
I absolutely disagree. I think that would be highly sufficient to justify a stop. I believe that here we don't have just a brown van. We have a brown van with tinted windows. Not just a brown van with tinted windows, but a brown van, tinted windows, and a Cape Verdean flag hanging from the rear. So obviously there was some miscommunication that left out the mirror, as opposed to the rear of the back. But nonetheless, an exact description is not required by the courts, and the information
so
received...
your answer to Justice Gantz's hypothetical, that's okay to come out of guns drawn and so on.
Absolutely, and they were not questioned, contrary to what defense counsel said. They were not questioned with drawn. In fact, they were not questioned at all. They were ordered to come out of the van. They were immediately handcuffed. When Officer Robert Smith stopped the van, he immediately radioed for assistance. Other officers came. The communication was then made to Boston. And then it wasn't until Detective Cummings arrived at the scene when he asked both defendants, in this case, for identifications and for their license. And that's when the questioning began, if you can call it that.
But
there was
they were asked whether they had just come from Boston.
Yes, they were. Forgive me. You're right. I forgot that one point. They were asked whether they just come from Boston, and I believe the answer was yes. and then they were handcuffed and seated on the side of the road. But any other further questioning was conducted by Detective Cummings when he arrived at the scene.
If I could shift for a moment to the car was seized.
Yes, after the car was seized, after Antonio Fidalgo then arrived at the scene with Detective Coleman, I believe, arrived, and several other homicide detectives. And as soon as he arrived at the scene, he immediately said, "That's it. That's the van that I saw." And contrary to what defense counsel said, there was no previous stops of any vans that came out at the suppression hearing. There was testimony at trial, however, that Antonio Fidalgo rode around with several other officers, and they saw several other vans, two to be precise, parked in the area. And he says no. But then he did see one, says that is a Dodge Ram 350. The car looks just like that. It's a large passenger van. But that did not come out at the suppression hearing. That was evidence that came out through testimony at trial.
So I assume the seizure was based on probable cause. I assume you need probable cause for that seizure.
Right. It was then obviously towed, and then a search warrant was then applied and executed the following day of the van. But there was never a search of the car, as defense counsel would like this court to believe. In fact, the entry to the vehicle, there was only two entries. One was by Officer Besrick, and that was the limited purpose of obtaining identification from the defendant, who said that his driver's license was in a wallet, in a jacket, in a car. And Officer Besrick went in through the front side passenger door, saw a greenish jacket, saw a bulge, and that's when he assumed it was a wallet, went in. It actually turned out to be a large bundle of cash. He left it on I believe, on the floor of the car at the direction of Detective Cummings. The second entry immediately...
Excuse me,
Yes.
Ms. Lee. Is it clear that Mr. Lopes gave the officer permission to go and get it?
Absolutely.
Okay.
I believe that you can read from the record that he consented to the officer's entry to obtain his driver's license from
I'm
his
sorry.
wallet.
You say it's clear because he said so, or you're clear because it's implied by his conduct?
I think it would be because it was implied by his conduct that he said he's obviously I believe
Why wouldn't the officer just say, "Well, could you get it for me"?
Because again, officers in this particular situation with a vehicle involved with a homicide, they're not expected to gamble with their safety. And in this case, where it's not a mere traffic stop, this specific van was wanted for a homicide in Boston. And for the officer's safety, an officer can go into the car, either a glove compartment, to obtain a registration or to get information himself. And again, in this particular case, the entries was limited for that sole purpose. The second entry, which was by Detective Schaff, he then he discovered that nobody else had made a protective sweep of this large passenger van. He went in to make sure nobody else was there, and given the tinted windows, they were unable to see whether there are other individuals in there. And then he found his identification located in the fourth row of the van.
Whose identification did he find?
He did. He found
Whose
Lopes, the defendant's.
Okay, so when the first officer went in to get the driver's license, he didn't find the driver's license.
That's correct.
He just found cash.
Yes.
And then the second officer went in and found another coat?
He did. He found a denim jacket that was
Different
long. A denim coat lying on the fourth row, the rear, I think it was the last row of the van. And he saw a wallet protruding from one of the pockets, and then he grabbed the wallet, gave it to Detective Cummings, and the defendant's license was then located.
There was no search of the car for guns?
Absolutely not. No. There's no
Before
test.
the seizure, I mean, before the car was...
Right, absolutely. Before it was towed. No, there's no search. Again, it was first for the identification and a protective sweep for other individuals in the car. And it wasn't until Antonio Fidalgo arrived at the scene and immediately identified the car, the van, that's when it was towed, and the search warrant was applied and subsequently granted and executed the following day.
Now, what do we do with the evidence that the police officer remembered that somebody invoked their right to silence, but he couldn't be sure whom?
This is the initial...
At the scene.
At the scene.
Right.
I don't think that came out. I mean, I think the other testimony, I'm trying to remember whose testimony that was.
Well, how did the judge deal with the issue that somebody invoked his right to remain silent?
I think Judge McAvoy looking at the totality of the circumstances, and based on the other testimony of the other officers, such as Cummings was there, Shaft, all the other officers says that they essentially agreed, they both agreed to accompany them separately to the police station for questioning.
Were they in custody at the time?
No.
Did that factor into the judge's decision?
Yes. They were, in fact, not in custody because when the communication was made to the Boston Police Department, I believe Detective Coleman spoke to Cummings and said, uncuff them, but keep them there just, I want to see if they want to talk to us.
But wasn't that after? I mean, my memory of the events, and again, it could be flawed,
There's a lot of
is that
events.
there was a police officer who questioned them. One of them said, "I've got nothing to say," or at least one or both. It differs depending on
Right.
on which time period, which testimony you credit. Then later, the word came from Boston, "Tell them they're not under arrest."
Right.
So, I mean, it seems as if they didn't learn that when they made that statement.
Right.
Is your position that they were not in custody at the time that they said it, or that they were in custody and then were taken and then were released from custody later on? Which is your position?
I remember reading that testimony very briefly, but then all the other testimony was that it did include that particular
But
sort
that
of-
doesn't go to the question is, were they in custody?
Right. I don't recall. I don't recall.
What don't you recall?
I don't recall whether they were still handcuffed. They were still handcuffed at the time or not. I don't recall.
Well, if somebody is in custody and exercises their right to remain silent and then are released, does the Miranda requirement that their invocation of the right to remain silent be scrupulously honored continue after the point they've been released?
I believe, and I've not read any cases about that recently, but I believe that if they were in custody and they were Mirandized and then subsequently released, I think that the determination is made by the time period of the release and the subsequent questioning.
Well,
I
that's certainly
think.
a standard if they
think.
continue to remain in custody.
If they continue to remain in custody, then Miranda is still good. But then in this case where they were handcuffed and then released.
Would it be the intervening event under Commonwealth versus Bradshaw? Would that be the test that would be applied?
I believe so. I haven't read that case in a while either.
Did the judge in this
Were
case?
they, I'm sorry.
No, go ahead.
Were they free to leave? I mean, was there a way that they could leave?
Ultimately, they actually did leave. In fact, Judge McAvoy found that after, I know I'm going ahead of myself, that after the interview.
No,
they were
I'm
free-
just talking about at the point when
Right.
they are, quote, free to leave. Are they, in fact, free to leave? By that I mean, is there a mechanism by which they
I
can...
submit to the court, yes. I believe that at the point where they were uncuffed at the directions of Detective Coleman,
Weren't they told they were free to leave?
I think they were told, I think the question was
I mean,
asked.
when they were uncuffed.
Right, when they were
Isn't that-
uncuffed, and
Isn't
I
that
think-
at least what he instructed?
I'm sorry.
The Boston police... I thought he said uncuff them and tell them they're free to leave.
Yes, I believe that was the case, but
And
see,
didn't the judge so find?
yes, she did so fine.
But the question is, did the Brockton police officer say, I'm taking the handcuffs off, you're free to leave? I know what the Boston
Right,
police
right,
officer
right.
told, said he was supposed to tell.
Did Judge McAvoy specifically find that the defendants were told they had the right to leave?
That's what mine...
I believe that in her ruling, but it's not in her findings. I don't think that's in the findings portion of her.
And what does she say in the rulings? I'm sorry, I don't have it in front of me at the moment.
I'm sorry, Your Honor?
I'm sorry, what does she say? You said it's in her ruling?
Yes, I believe it's in her ruling that she ruled that based on her findings that the defendants were free to leave at that time. The defendant was free to leave.
But we don't know
But-
whether they were told.
Right, but that whether they were told or not, that's not in the body of the findings.
Okay.
Now, what statements were made on April 23rd that are of consequence? Were any offered into evidence at trial?
Actually, none of consequence. In fact, the officer testified at the suppression hearing that he was reticent, he was of no help, and essentially what occurred at the interview at the Brockton Police Department, they noticed a bulge in his pocket that turned out to be a bundle of cash. He didn't know how much was in it. He didn't feel like counting it. He said that he got the money from a friend. They noticed a watch that was hanging loosely from his wrist. They also took that, and they asked him where he got it, and he said, I found it in the van.
So that was admitted at trial. Those are statements made on April 23rd at
Those
the
were made
police
at 24th.
station.
Yes.
And they were admitted at trial.
I believe that they were, but I think the bulk of what was admitted at trial was his subsequent confession, which was
I understand, but I'm just trying to get at Justice Gantz's question.
Yes.
So none of the statements made up until the time they were at the police station, were even admitted into evidence?
No.
They weren't.
Okay,
Okay, you don't know.
I don't know. Trying to remember if he was asked, if the detective was asked that at trial. I'm not clear
Okay.
on that. Unless the court has any other questions, the last argument that I obviously would make is that the court should deny any and all relief under Section 33E. The weight of the evidence in this particular case is incredibly strong. There was a confession in this case of an atrocious murder of the defendant's father's best friend, who also happened to be murdered on his birthday. And for that reason alone, the court, not alone, but for all the other reasons, the court should affirm the convictions. Thank you.
Thank you, Ms. Lee.